You're at trial. It's a medical malpractice trial. And now the jury is deliberating. Can the judge approach the defense attorney and say, listen, the plaintiff, the injured patient, has a fantastic case, and if I were you, I'd make a phone call to your insurance company and try and settle this before the jury comes back with a verdict. Can the judge do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, the judge can do that. While the jury is out deliberating, the attorneys are in the courtroom or in the courthouse, walking around. They're waiting for the jury to come back with a verdict. And now there are instances where the attorneys will be in the courtroom, the judge will also be in the courtroom doing paperwork or talking, and now he says, "Counselor, approach." And now the defense attorney goes up and they have a conversation. And the judge may honestly tell the defense attorney, listen, I thought the plaintiff, the injured patient, has a great case. And there's a great possibility that the jury is going to come back and give him a verdict far in excess of what you're willing to pay. You may want to reconsider about trying to negotiate this case and settle it before the clock is ticking and before the jury comes back with a verdict. That can happen. And now the defense attorney has to make a decision about whether or not what the judge is saying has merit, whether or not he actually has time before the jury comes back to go ahead and call his insurance company to start negotiations, because if the jury comes back with a verdict first, then he's out of luck. Time's up. Whatever the jury comes back with, he's got to live with. So there are instances where the judge will try and approach the defense and say, listen, you may want to try and go negotiate this case. At the same time, the judge can also try and approach the plaintiff's attorney, because let's say the defense has tried to negotiate before, and for whatever reason, their offer was not enough. So now he may want to put pressure on the plaintiff's attorney to try and get the client, you, the injured patient, to take a lower amount of money, saying, hey, wait a second, the defense has a great case, and there's a possibility the jury is going to come back with a verdict that throws you out of court, and you get nothing. The judge can do that. He can try and put pressure on each side to get them to realize nobody knows what the jury is going to do, and nobody knows exactly when the jury is going to come out and announce their verdict. So you're under the gun, and now you have to reevaluate, and each side has to go back to their respective clients and now begin talking to see whether or not first they're willing to negotiate, and if so, can they get this done before the jury comes back with their actual decision. So why do I share this great information with you? I share this with you because this happens often in cases involving accident matters, involving medical malpractice cases, as well as wrongful death matters here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.